just like everything else in 2023, there's a lot of bad information out in the community. When it comes to estate planning, there's a lot of bad information online. I'm sure there's some good information out there as well. It's just kind of hard to kind of sort through it to find the good stuff. And so there's a lot of common misconceptions. One misconception of estate planning, for example, is that spouses are already each other's powers of attorney. That's not the case. We've seen when the rubber has met the road on that quite a few times. But coming to this stuff specifically, the biggest misconception we probably see is a lot of people tend to think, hey, I've got a will. It says where my stuff's going to go after I pass away. So I'm going to stay out of court. Nobody's going to fight, all of that kind of stuff. In fact, all a will is an instruction sheet for court or an instruction sheet for probate. A will can only govern assets that actually go through that probate process. We don't want to be in probate. A huge part of what we do here is set people up on the front end to stay out of court and to stay out of probate. It's a gigantic headache. And so if you're using your will, you are likely in court. And so with a will, you designate, as you guys probably know, you designate somebody called a personal representative in Colorado. It used to be called an executor. That's kind of the person that's in charge of the show. That person has no legal authority unless they're actually appointed by a court in a probate case. And so when we do probate, if I meet with somebody and they need to go through the probate process, if they want us to represent them, the first thing I usually do is file the will. And then if that hasn't been filed with the court, and then I file a big application to actually have that personal representative officially get appointed. When the court appoints them, they issue a court order. That order is called letters, and it's either called letters testamentary or letters of administration. And that's kind of what we're talking about here. And so all that is it's a court order that says this person, so-and-so, has now been appointed as personal representative, and they now have authority to act on behalf of this person's estate who passed away. And so once the court issues that order, those letters, it's just a piece of paper. They can take that to a bank to get funds released, and they can sell a house with those letters. And so that's actually what gives them their legal authority. The difference in the two names between the letters of administration and the letters testamentary are, if you had a will, it's letters testamentary. If you didn't, it's letters of administration. And so if you died intestate without a will, it's called letters of administration. But that's basically the two differences there. It's just if we're probating a will, if we're kind of probating an intestate estate. Those are the two differences. But legally, either one, it does the same thing. Once you get that order, it should give you all the same powers, unless the court restricted it for some reason, which they don't usually do. Yeah, and so the goal for us is, just to add on, the goal for us then is to never have that personal representative get appointed, because then you're in probate. And so we want things, everybody needs a will, but we want things to transfer outside a will.